A federal courtroom is now examining the business structure behind the Eras Tour, and the path there runs directly through Taylor Swift, amplified by a cultural spotlight that has also included figures like Blake Lively. This isn't just celebrity visibility, it's federal scrutiny. While images of Taylor Swift and Blake Lively circulate across media cycles, reinforcing influence, access, and elite proximity, the U.S. Department of Justice is advancing an antitrust lawsuit in New York federal court against Nation and Ticketmaster. But this changes the equation, because what looked like a chaotic verified fan presale, the system overwhelmed, the queue froze, fans charged multiple times, resale prices exploded across the secondary market, is now being examined inside a courtroom as part of a broader DOJ investigation into exclusive contracts, venue control, and vertical integration. The temperature rises from optics to oath. The same week celebrity alliances trend, executives prepare to testify. The same system that processed the Eras Tour is being evaluated for potential monopoly power and whether competitors were effectively locked out. That wasn't the only complication. Industry rivals like AEG and SeatGeek are positioned to challenge the structure. Decisions under Michael Rapino, dating back to the 2010 merger, are being placed under renewed examination. When fan outrage, corporate infrastructure, federal enforcement, and celebrity proximity collide, the story shifts categories. It stops being just a PR nightmare. It becomes structural exposure. What unfolds at trial could determine whether the live entertainment pipeline remains intact or faces a forced breakup. The verdict won't just clarify contracts, it will test the architecture of power behind the stage. When Eras Tour tickets went live, demand didn't just spike, it detonated. Millions of Swifties entered the verified fan presale within minutes. What followed wasn't a smooth digital rollout, it was a system overwhelmed. A queue that spun endlessly, pages that froze, buyers logged out mid-checkout, fans reporting they were charged multiple times without confirmation. The frustration was immediate. The documentation was relentless. Screenshots spread across Reddit threads. Video recordings showed stalled dashboards. Accounts of disappearing inventory stacked up by the hour. Ticketmaster acknowledged extraordinary demand. Live Nation cited traffic volume. But this changes the equation. Within hours, tickets surfaced on the secondary market. Resale prices exploded, in some cases reaching multiples of face value. Allegations involving bots and scalpers intensified. Fans began questioning not just execution, but structure. Why were service fees and service charges stacking so high? Why did alternatives seem absent? Why did the same entity control promotion, ticketing, and venue access? The meltdown stopped looking like a technical failure. It started looking systemic. Behind the presale chaos sat the framework built after the 2010 merger between Live Nation and Ticketmaster, a consolidation that combined promoter power, ticketing infrastructure, and venue relationships under one umbrella. Critics pointed to exclusive contracts, entrenched venue control, and deep vertical integration. That reframed the conversation. Because high demand isn't illegal, infrastructure strain isn't automatically misconduct, but when breakdowns expose concentration risk, regulators pay attention. Lawmakers referenced prior Congress hearings, commentators revived discussions around monopoly power. Analysts began re-examining whether market entry for competitors had been effectively constrained. The cultural scale mattered. The artist at the center was Taylor Swift. The audience was massive. The documentation was public. The outrage was organized. And visibility alters scrutiny. What began as a backlash cycle evolved into something far more consequential, momentum that aligned with a growing DOJ investigation examining antitrust concerns tied to market structure. The presale collapse wasn't the lawsuit. It exposed pressure points that were already under review. And once those weaknesses were visible at scale, the conversation moved from fan frustration to federal oversight, culminating in proceedings now unfolding in New York federal court. The meltdown didn't create the case, it amplified it. The U.S. Department of Justice isn't arguing that the Eras Tour presale was chaotic. It's arguing something far larger. In its antitrust lawsuit, the DOJ alleges that Live Nation and Ticketmaster operate with market power that may have limited competition across the live entertainment pipeline, not just ticketing, the entire structure: promotion, venue access, artist relationships, and distribution. That distinction matters, because this case isn't about angry Swifties. It's about whether the framework created after the 2010 merger allowed one entity to consolidate leverage in ways that competitors struggled to penetrate. According to the filing, the government is examining exclusive contracts with venues, long-term agreements that critics argue reduced competitive bidding, the structure of venue control, the impact of vertical integration, where the same parent company promotes tours, manages venues, and sells tickets. The allegation isn't framed as inconvenience, it's framed as concentration. The complaint references market dominance in major amphitheaters and arenas. It raises the question of whether competitors were effectively locked out of key access points. It examines whether artists and venues had realistic alternatives. And here's where it becomes consequential. If the court determines that the structure violates federal antitrust standards, potential remedies range from behavioral restrictions to structural separation, including a possible breakup of parts of the business. That's not speculation. That's part of the legal framework available in federal enforcement actions. Live Nation has publicly contested the claims, arguing that competition exists, that infrastructure investments improved efficiency, and that high demand, not exclusion, drove the verified fan presale collapse. The company has pushed back against the monopoly label, stating that market share alone does not equal unlawful conduct. The courtroom now becomes the filter. Executives may testify, economic experts will likely model competitive dynamics, internal communications, contract language, and venue agreements could be examined under oath in New York federal court. And this alters the temperature, because when scrutiny shifts from social media to sworn testimony, the standard changes. Assertions must be documented, claims must be supported, market definitions must be precise. The DOJ investigation isn't centered on celebrity optics, it's centered on structural dominance. But the cultural catalyst remains relevant. Without the scale of the Taylor Swift moment, without the visibility of the presale breakdown, the public pressure surrounding enforcement may have evolved differently. Now, the legal argument stands on its own. The question before the court isn't whether fans were frustrated, it's whether the architecture of the live music industry complies with federal competition law, and that determination carries consequences far beyond a single tour. To understand why the antitrust lawsuit matters, you have to understand the structure. Live Nation isn't just a promoter. Ticketmaster isn't just a ticketing site. After the 2010 merger, the combined entity operated across multiple layers of the live music pipeline: tour promotion, venue relationships, ticket distribution, and ancillary revenue streams. That concentration is central to the DOJ investigation, because when one parent company manages promotion and ticketing and maintains deep relationships through exclusive contracts with venues, critics argue the leverage compounds. Control at one layer reinforces influence at another. The government scrutiny focuses heavily on vertical integration, the blending of roles that, in theory, could shape bargaining power. For example, if a venue partners long-term under exclusive contracts, competitors may struggle to access prime dates. If promotion and ticketing operate under the same corporate umbrella, pricing structures and service fees may follow a unified model. If ticketing scale dominates distribution, new entrants face steep infrastructure barriers. None of that is automatically unlawful. Scale alone does not equal a monopoly under federal antitrust standards. But scale combined with restrictive agreements is where examination intensifies. This is the corporate layer that often gets lost in the celebrity narrative. Because while the public remembers the verified fan presale collapse, regulators are studying contract mechanics, revenue splits, market definitions, competitive substitution, and this complicates the landscape. Rivals like AEG and platforms such as SeatGeek argue that entering certain markets requires access that is difficult to obtain when venue relationships are already embedded. Industry executives, including Michael Rapino, maintain that competition exists and that market dynamics are more fluid than critics suggest. The tension isn't just about ticket prices, it's about access. Access to venues, access to distribution channels, access to artists negotiating tour infrastructure. When those channels overlap under one corporate framework, the leverage conversation shifts from consumer frustration to structural economics. Financially, the ecosystem is massive. Promoter revenue, ticketing fees, premium seating packages, and resale dynamics intertwine. When resale prices exploded during the Eras Tour, it amplified questions about how the pipeline functions under concentrated control. But here's the legal threshold. For the court to impose structural remedies, including a potential breakup, the government must demonstrate not just size, but anti-competitive impact, evidence of foreclosure, evidence that competitors were effectively locked out beyond ordinary market competition. That is a high bar, and it's why the corporate mechanics now sit at the center of what unfolds in New York federal court. The narrative may have begun with Swifties and outrage, but the outcome will hinge on contracts, leverage, and whether the architecture of Live Nation and Ticketmaster withstand federal scrutiny. Now the focus shifts to exposure. Because once a case reaches trial in New York federal court, arguments leave press releases behind and enter sworn testimony. The U.S. Department of Justice must move beyond theory. The antitrust lawsuit will hinge on documents, internal communications, economic modeling, and witness credibility. And the witness list matters. Senior leadership at Live Nation and Ticketmaster could be called to testify about contract structures, venue negotiations, and strategic intent behind the 2010 merger. That includes scrutiny surrounding executive decisions made under Michael Rapino's tenure. But the exposure doesn't stop there. Rival executives from AEG and competitors like SeatGeek may present their perspective on market access. They could describe attempts to enter or expand within venues governed by exclusive contracts. They could outline whether they felt effectively locked out of meaningful opportunities. That contrast will shape the courtroom narrative. Because the government's burden is not to show scale alone, it is to demonstrate anti-competitive effect under federal antitrust law. Economic experts will likely debate market definitions. What constitutes the relevant market? Is it primary ticketing, major amphitheaters, national touring infrastructure? Those definitions determine everything. And then there's documentation. Internal emails, negotiation terms, venue agreements, revenue splits tied to service fees and bundled promotion. Each document becomes a puzzle piece in evaluating whether vertical integration enhanced efficiency or constrained competition. But here's where public interest intensifies. The cultural backdrop of the Eras Tour remains unavoidable. The scale of the verified fan presale collapse, the visibility of Swifties, and the prominence of Taylor Swift created national attention that now shadows the courtroom. Even adjacent celebrity proximity, including the amplified media focus surrounding Taylor Swift and Blake Lively, contributes to the public lens through which the trial unfolds. While not legally central, visibility influences scrutiny. The legal process, however, narrows the frame. No trending hashtags, no viral screenshots, only admissible evidence. If the DOJ investigation substantiates claims that competitors were systematically disadvantaged through contract leverage, the court could consider remedies that range from operational restrictions to structural separation, including a potential breakup. If the defense demonstrates that competition remains viable and that scale reflects consumer preference rather than exclusion, the claims may be limited or narrowed. The trial stage introduces uncertainty for both sides because testimony can clarify or complicate. And once executives answer questions under oath, the narrative becomes anchored, not in outrage, but in record. While the courtroom debate centers on antitrust definitions and exclusive contracts, a parallel battle is unfolding outside the courthouse: reputation. Because the Eras Tour wasn't just a tour, it was a cultural event. And when the verified fan presale collapsed, when the system overwhelmed, when fans were charged multiple times, when resale prices exploded, the frustration wasn't directed only at Ticketmaster. It radiated outward, toward Live Nation, toward the structure, and inevitably toward Taylor Swift. Not as a defendant, not as a party to the antitrust lawsuit, but as the artist at the center of the moment that amplified scrutiny. That distinction is important. Legally, the DOJ investigation examines corporate conduct and market structure, but culturally, public perception doesn't always separate artist from infrastructure. When Swifties mobilized online, the language shifted from logistics to loyalty. Questions emerged. If the system was flawed, why remain silent? If fans felt disadvantaged, should influence be leveraged? If the pipeline is under federal review in New York federal court, what role does the most powerful touring artist play? Silence in high-visibility moments becomes narrative space, and narrative space fills quickly. Media cycles amplified images of Taylor Swift in elite social circles, including appearances alongside Blake Lively, reinforcing perceptions of proximity to power at the same time that fans were challenging corporate dominance. The optics created contrast: exclusivity on one side, accessibility concerns on the other. None of that is evidence of legal exposure, but it is reputational pressure, because brand equity operates differently than federal law. The courtroom evaluates contracts and competition. The public evaluates alignment and advocacy. That tension creates risk. The phrase PR nightmare began circulating not because of courtroom filings, but because of emotional disconnect. Fans who once framed the Eras Tour as celebratory began revisiting the backlash narrative through the lens of fairness and access. And this is where stakes extend beyond the verdict. If the court narrows the antitrust lawsuit, corporate consequences may be limited, but reputational memory can linger. If remedies escalate, including the possibility of structural changes within Live Nation or Ticketmaster, the cultural association between the presale collapse and Taylor Swift may resurface in future cycles. Public perception rarely tracks legal nuance. It tracks moments. The presale collapse was a moment. The federal case is a process. The reputational dimension sits in between. And that middle layer, where celebrity visibility intersects with structural scrutiny, may prove just as consequential as the ruling itself. Now, everything converges. The antitrust lawsuit brought by the U.S. Department of Justice isn't symbolic. It carries enforceable consequences. And once proceedings advance inside New York federal court, the range of potential outcomes becomes very real. At one end of the spectrum, behavioral remedies. The court could impose restrictions on certain exclusive contracts. It could limit how Live Nation bundles promotion with Ticketmaster ticketing. It could require structural firewalls within the framework of existing vertical integration. That would not dismantle the company, but it would alter leverage. At the other end, structural remedies. If the government meets its burden under federal antitrust law, the court could consider separation measures, including a potential breakup tied to the legacy of the 2010 merger. That would mean disentangling promotion from ticketing, reshaping venue relationships, and redefining how tours scale nationally. That threshold is high. Courts do not impose structural remedies lightly. The DOJ investigation must demonstrate sustained anti-competitive impact, not just market size, not just frustration from the verified fan presale, but legally cognizable harm to competition. And the defense will argue precisely that. Live Nation and Ticketmaster have maintained that competition exists, that artists retain choice, and that infrastructure investment improved efficiency across large-scale tours like the Eras Tour. They contest the monopoly framing and reject the idea that rivals were categorically locked out. The ruling, whenever it arrives, will not be about celebrity. It will be about structure. But structure influences culture. If operational limits are imposed, ticket pricing dynamics, service fees, and venue negotiations could evolve. If separation occurs, the live music ecosystem may fragment into new competitive tiers. Competitors like AEG and platforms such as SeatGeek could expand under revised access conditions. And if the claims are narrowed or dismissed, the existing architecture remains intact, reinforced by judicial validation. That's the binary many observers focus on, but the broader consequence is precedent. A federal decision addressing promoter ticketing integration will echo across the entertainment industry. It will shape how regulators approach concentration in adjacent sectors. It will influence how future mergers are evaluated. The Eras Tour presale collapse ignited visibility. The trial tests structure. The outcome defines trajectory. Whether through restriction, recalibration, or reinforcement, the ruling will extend beyond one tour, one artist, or one moment of backlash. Because when federal enforcement meets consolidated infrastructure, the implications rarely stay contained. The trial will eventually produce a ruling, but not every question raised by the Eras Tour moment will be answered inside New York federal court. The antitrust lawsuit brought by the U.S. Department of Justice will determine whether the structure created after the 2010 merger crosses a legal threshold. It will assess exclusive contracts, vertical integration, and whether competitors were effectively locked out in ways that violate federal antitrust law. That resolves the legal loop, but two others remain. First, the cultural loop. The presale collapse, the verified fan presale, the system overwhelmed, the anger from Swifties, and the surge of resale prices reshaped how fans view access. Regardless of the court's decision, that moment altered perception. The association between Ticketmaster, Live Nation, and the scale of the Eras Tour won't simply disappear. Second, the power loop. If the court narrows the claims, the existing infrastructure stands reinforced. If remedies are imposed, even short of a full breakup, the live entertainment pipeline shifts. Competitors like AEG and SeatGeek could gain breathing room. Contract dynamics could evolve. Pricing structures, including service fees, could face renewed scrutiny. And hovering over it all is visibility. The cultural prominence of Taylor Swift, the amplified media attention that even pulled figures like Blake Lively into parallel narratives, that spotlight accelerated scrutiny. But the outcome now rests on documentation, testimony, and judicial interpretation. The verdict will settle the legal question. It won't settle the structural debate. Because once federal enforcement targets concentration at this scale, the ripple effects continue long after the headlines fade. If you want updates as this case develops, filings, testimony, and what each ruling actually means, subscribe and stay with us. This isn't just about one tour, it's about who controls the stage.